Okay, so today po papag-usapan natin yung most recent development po sa case ni FPRRD sa ICC kasi nung May 1, 2025 po nag-file po or may final po yung lawyers niya, si Atty. Kaufman, si Atty. Jacobs, kung saan china-challenge po nila yung jurisdiction ng ICC over the case po of FPRRD. Okay, so good day po everybody. This is AttorNEIL Abayon po, your quote-unquote favorite DDS lawyer. At today po, yan yung explain ko sa inyong lahat. Okay, so unang-una po na kailangan talaga natin tandaan dito or kailangan nyo i-take note po talaga is that this is a defense po filed by the lawyers of FPRRD, okay? So ang ibig sabihin po niyan, lahat po ng madidiscuss dito for today's video po are favorable to FPRRD. And the reason kung bakit po yan binabanggit is kasi po pag hindi kayo DDS, if you are let's say part of the Liberal Party, part of the Makabayan, or part po kayo ng alyansa, baka po uminit yung ulo ninyo pag panoorin ninyo to, okay? However, ang masasabi ko lang po, kung hindi kayo DDS, baka naman po open-minded kayo to legal discussion. So hopefully po panoorin nyo pa rin po itong video para at least po magkaroon kayo ng idea, yung legal side of things naman po dun sa defense ni FPRRD. Okay, so yan lang po yung pinakaunang gusto ko klaruhin. Okay, so first and foremost po, kailangan natin tingnan that this is a legitimate document po to galing sa ICC. So ilalagay ko na lang po yung source ko dito, yung link po ng document mismo sa description or sa comment section po. Okay, so makita naman natin sa upper left nakalagay po talaga dyan International Criminal Court. So ito po kinaklarify ko lang lahat yung authenticity of this kasi alam naman po natin very big issue po sa bansa natin yung fake news. So ayoko naman po mapagalitan or makasuhan or matawag tayo sa Quadcom, okay? So this is a verified and authenticated document po. You can get a copy from this sa ICC website po. Again, ilalagay ko na lang po yan sa comment section or sa description. So makita po natin sa upper left nakalagay dyan International Criminal Court, as it is addressed to the pre-trial chamber, and then it is also addressed to the judges, yung tatlong judges po na nakita natin dun sa first conference hearing po ni FPRRD. Okay, so makikita natin yung subject matter dito. This is the situation in the Republic of the Philippines. So yung situation in the Republic of the Philippines, for some reason situation kasi yung tawag nila sa mga cases sa ICC. Okay, so this is versus the prosecutor versus Rodrigo Roa Duterte. Baka curious kayo kung bakit in the case of prosecutor, ito po yung equivalent sa atin, di ba sa atin tawag is people versus ganyan kung sino man yung akusado. However doon, since yung pinakakalaban nung defense ng accused is the prosecutor, kaya yan, in the case of the prosecutor versus Rodrigo Roa Duterte. And of course, ito pong idinidiscuss natin is the defense challenge with respect to jurisdiction. Okay, so this is the document that was filed by Atty. Kaufman noong May 1, 2025. Makita din po natin yan sa lower right yung date kung saan china-challenge po nila ngayon yung jurisdiction ng ICC over the case ni FPRRD. Okay, so yan po yung pinakauna. So ngayon punta na po tayo sa substance proper ng case. Okay, so ito pong introduction, hindi ko na po ito iisa-isahin kasi medyo mapapahaba po tayo masyado. Pero more or less po kasi ang pinaka-defense talaga dito na ginamit talaga ng lawyers po ni FPRRD is the difference. They differentiated po jurisdiction over the subject matter versus exercise of jurisdiction. So yan po yung tinatawag dito ng lawyers ni FPRRD na jurisdiction stricto sensu on the one hand versus yung exercise of jurisdiction on the other hand. Okay, so ito po kasi yung one of the big misconceptions regarding this case kasi kung makikita po natin, laging sinasabi ng mga anti-FPRRD na merong jurisdiction over the subject matter considering na yung case daw na in-investigate, yung mga kasong inimbestigahan si FPRRD were all cases during the time po na member pa yung Pilipinas sa Rome Statute. Okay, so dun po sa argument na yan, wala pong question dyan. Okay, however, kailangan po kasi natin ma-differentiate yung jurisdiction over the subject matter versus the exercise of jurisdiction. So yan po yung in-explain nila. So yung jurisdiction over the subject matter po, ito yung authority ng korte para hawakan yung certain types of cases. So in the case of FPRRD po, from the time ng 2011 up to the time of withdrawal, yun po yung case na merong jurisdiction yung ICC over. Okay? However, hindi po automatic porket may jurisdiction over the subject matter yung ICC is ibig sabihin yan that will equal agad po to what we call the exercise of jurisdiction. Okay? Kasi ang exercise of jurisdiction po, ito na po yung power ng korte kung saan ginamit na or in-exercise na nga po ng korte yung authority niya or yung power niya to actually proceed with the proceedings of a case proper. So iba po yan, magkaiba po yan na mix and match po kasi talaga most of the time yan yung jurisdiction over the subject matter versus exercise of jurisdiction. So yan po yung one of the main arguments dito ng lawyers ni FPRRD. Okay? So dito po kung makikita ninyo sa paragraph 17 po sinabi sabi po talaga ng lawyers ni FPRRD dito is that the true issue in the present instance is whether dormant jurisdiction stricto sensu could be triggered daw po ba, and whether the court could properly exercise jurisdiction after the Philippines effective withdrawal from the Rome Statute. Okay? Kasi kung tatandaan po natin, magkaiba nga po yung exercise or yung paggamit na ng jurisdiction versus yung actual jurisdiction over the case. So dito po hindi kine-question ng lawyers na FPRRD na posibleng may jurisdiction over the subject matter yung korte. However, yung main argument po nila is that there were already lapses po dun sa pag-exercise ng jurisdiction. Okay? So bago ko po i-explain yung sa side ni FPRRD, explain ko po muna yung pinaka-common dito na scenario sa atin. So dito po kasi sa atin, we have what we call prescriptive periods kung saan pwede ka lang po mag-file ng case. Okay? At kung lumampas na po yung prescriptive period, hindi ka na po pwede mag-file ng case kahit na po may jurisdiction yung korte over that case. Meaning, since nag-lapse na po yung prescriptive period, hindi na po pwede ma-exercise ng court yung jurisdiction niya over that subject matter. So more or less po, by analogy, parang ganito po yung argument dito ng lawyers ni FPRRD. Kasi yung argument po nila, nag-withdraw na po yung Philippines noong 2019 pa. However, yung proper investigation po ng prosecutor ng ICC is nag-start lang noong 2021. Therefore, since there is a difference between the exercise of jurisdiction versus the actual subject matter jurisdiction, dun po sa exercise of jurisdiction, nagka-problema yung prosecutor. Yan yung argument po nila dito. Okay? So ngayon, punta po tayo sa actual arguments po ng lawyer ng FPRRD. So dito po in paragraph 18, may kita po ninyo dyan. Sinite po nila yung provisions relating to the exercise of jurisdiction under po to ng Rome Statute. So sabi po nila dyan, the capacity to exercise jurisdiction as distinct from the existence of jurisdiction is predicated on the fulfillment of the conditions set out in Article 12, paragraph 2. So in Tagalog, ang ibig sabihin po niyan, may specific guidelines po yung Rome Statute natin kung paano maka-exercise yung court ng jurisdiction niya over cases na iniimbestigahan po ng prosecutor. Okay? So nasa Article 12 po yan. And then that provision lists two possible and alternative preconditions to exercise jurisdiction which are founded on territory and nationality. So skinip ko na po yung ibang discussions regarding Article 12 kasi hindi naman na po talaga siya super crucial to the discussion po natin. So on paragraph 20 po, pumunta naman ngayon yung lawyers po ni FPRRD. They discussed Article 13. So in conclusion po, kinompare po nila ngayon or pinag-aralan po or diniscuss po talaga yung Article 12 and Article 13 ng lawyers niya. And then from there po, yung conclusion nila is that may kita po talaga natin na meron daw clear distinction as provided as drawn by the Rome Statute between jurisdiction on the one hand and exercise of jurisdiction on the other hand. So ibig sabihin, yun nga po, merong difference yung jurisdiction over the subject matter of the case versus the actual exercise of jurisdiction as clearly provided daw po dun sa Rome Statute. Okay, take note po pala, hindi ako yung nagsasabi nito. I am simply reading po kung ano yung sinabi dito ng lawyers na FPRRD, and I'm just trying to explain it to you guys, yung mga viewers po, as simple as possible para po mas madali ninyo maintindihan. Okay? So sabi po nila dito, consequently, while the existence of jurisdiction must be determined with respect to the date of the commission of the alleged crimes, a plain reading of Article 12 and 13 indicates that the appropriate moment to determine the preconditions to the exercise of jurisdiction is when the court's jurisdiction is triggered under Article 13. Okay, so i-summarize po natin yan. Ang sabi po nila, nakalagay daw sa Article 12, a plain reading of Article 12 indicates na magdedetermine kung merong subject matter jurisdiction yung court on the time of the date of the commission of the alleged crimes. Yun po yung magdedetermine as to the subject matter jurisdiction po yun. However, nakalagay po sa Article 13 ngayon kung kailan magsa-start yung pag-exercise ng jurisdiction ng korte over that case nga po na pinapag-usapan nila. Okay? So dito po ang sabi ng lawyers po ni FPRRD is that ang inadapt daw ng prosecutor is Article 13C of the Rome Statute. Okay? So yung Article 13C po ng Rome Statute, ang nakalagay po dyan is that the prosecutor has initiated an investigation in respect of such crime in accordance with Article 15. Okay? So ang ibig sabihin po niyan, nag-start po yung pag-exercise ng jurisdiction ng korte upon the start of the investigation ng prosecutor. Okay? Kasi yun nga po, ang ginamit pong basis ng prosecutor dito para ma-exercise yung jurisdiction is Article 13, paragraph C. So therefore, yung exercise of jurisdiction started po upon the investigation, upon the start of the investigation po ng prosecutor. Okay? And then yung sa Article 13, paragraph C po, nakalagay kasi doon is that dapat mag-comply yung prosecutor na under Article 15 din po ng Rome Statute. So under Article 15 ng Rome Statute, may specific specific requirements po yun doon. One of which is yung mag-a-apply muna siya na mag-investigate siya doon sa pretrial chamber, and then yung pretrial chamber po is maglalabas din ng order or judgment whether or not papayagan ba niya yung prosecutor na mag-conduct nung investigation. So dito po ang nangyari sa case ni FPRRD is that the former prosecutor adopted the Article 13C triggering mechanism on 24 May 2021. So May 24, 2021 po nag-apply yung prosecutor para mag-investigate na siya dun sa pre-trial chamber, okay? Pero tandaan po ninyo, yung withdrawal po ng Philippines from the ICC took effect po in 2019 pa po, okay? Specifically, nakalagay po yan din dito. Specifically, March 17, 2019 po naging effective yung withdrawal ng Philippines, okay? So tandaan po ninyo, nag-start po yung investigation or nag-apply po na mag-investigate lang yung prosecutor was only in 2021 or 2 years after na po the withdrawal. Okay, and then in-emphasize din po dito ng mga lawyers na FPRRD, like what I've stated earlier nga po, is that if under Article 13C yung basis nila for the exercise of jurisdiction, it must fully comply daw po with Article 15, considering yung 13C refers to Article 15 in its totality. In short, madami-dami po yung requirements. However, nagka-issue na nga po since nag-start lang sila mag-apply for investigation on 2021, 2 years after the withdrawal na po. And the same was approved lang ng pre-trial chamber on September 15, a couple of months after nung application nila. So dito po talaga nag-rest heavily yung arguments po ng lawyer ni FPRRD is that meron ng lapses sa procedure ng pag-exercise ng jurisdiction, okay? So hindi po talaga nila masyado question dito yung whether or not may jurisdiction ba over the subject matter yung ICC. Rather, ang kina-question po talaga nila is wala na or improper yung pag-exercise jurisdiction due to the lapses dun sa procedural matters, okay? And it is basic po kasi dito po sa atin sa Philippines po, it is basic that if there is an improper enforcement or an improper exercise of jurisdiction, ang proceedings pa rin po ng kaso can be considered as null and void po, meaning wala pong maging epekto yung judgment in cases like that, okay? So ngayon punta po tayo sa next argument ng defense against dun sa term or expression na quote and quote by the court. Okay? Kasi ito pong expression na to is very important to this case kasi pag makonsider yung term na by the court kasama yung prosecutor, ibig sabihin po nito lahat po ng mga preliminary matters na ginawa nung ICC nung I believe it was in 2016, pwede na yun siya makonsider as pasok dun sa Article 13C and Article 15 of the Rome Statute. Okay? So dito po inargue ng lawyers na FPRRD na yung term na yun na by the court dun sa Rome Statute is that hindi daw po included yung term dun na prosecutor. Ang sabi po dito ng defense, yet a careful and systematic analysis of the Rome Statute and the rules of procedure and evidence shows that in nearly all instances where the term by the court is used, it refers to the judiciary to the exclusion of the prosecutor. Okay, so ito po talaga is very important issue to na papabor kay FPRRD, assuming na pumabor yung judges dito sa argument na to nung kanila Attorney Kaufman. Kasi pag ito po mapaboran ng korte, mapaboran po ng ICC, ng judges ng ICC, automatic na wala na pong issue agad na walang jurisdiction or improper yung pag-exercise ng jurisdiction kasi yung mga preliminary matters na ginawa ng ICC noong 2016, hindi yun siya papasok under investigation dun sa requirement ng Article 13C at paragraph 15 po ng Rome Statute. Kasi yun nga po, again, ulitin ko para mas maintindihan nyo talaga, ang ginamit po ng prosecutor dito na basis para umandar na yung exercise of jurisdiction ng korte is Article 13C. So dun po kasi nakalagay dyan specifically na kailangan mag-undergo ng investigation ng prosecutor para umandar yung exercise of jurisdiction. Kaya ito kuna-question talaga ng defense lawyers ni FPRRD kasi yun nga, pag ma-establish talaga clearly na yung term by the court does not include the prosecutor, therefore hindi na-conduct yung investigation na required ng Article 13C and Article 15 noong 2016 pa. Okay, so yan po. This is a very interesting issue po na pag pumanig kay FPRRD is very favorable po to sa kaso niya. So ngayon, ang next question po natin, ano ba ibig sabihin itong lahat ng diniscuss ko? Ibig sabihin ba nito na mabibring home na natin si FPRRD or tuloy pa rin ba yung detention niya doon? Okay? So tatandaan po natin, this is a defense pa lang po na final ng lawyers niya. Ibig sabihin, subject for approval pa po to ng judges. Therefore, hindi po automatic na marirelease na si FPRRD. Okay? However po, yung maganda dito sa defense nila Attorney Kaufman, madami pong matters dito which are issue issues or which are matters of first impression. Therefore, it is open for argument po talaga. At pag ganyan po, pwede pa po talaga yan pag-usapan, i-argue at posible pong mag-grant ng ICC judges considering itong mga diniscuss nila ay may legal basis naman po eh. They are highly logical. Tapos meron din silang mga cases dito na sinite kung saan ginamit ng prosecution pero in-argue nila na improper yung application ng prosecution to the case. So in summary po, kung ako tatanungin, this is a very good presentation po of the defense of FPRRD. However, we also have to remember, hindi po automatic porkit final to is makakalabas agad si FPRRD. Hindi po yun ganon. Pero yun nga po, since there are issues here which are discussed for the first time, it is going to be a very interesting case po once decisionan po to ng mga judges nung ICC. And in case po interested kayo to other videos ko na related to this, ilalagay ko na lang po yan somewhere dito para pwede nyo rin po panoorin. Yung iba po actually dito is na-touch on ko na rin to eh dun sa mga past videos ko in relation to ICC. Okay? So hopefully klaro tong discussion natin. So if you like legal educational videos, follow lang po kayo sa akin. Until next time, see you all po. Bye-bye!